Assalamualaikum and hello everyone. I'm BINTI ISMAIL. You can call me Syahira. I'm from Kuantan and previously I'm studying Diploma in Law UNIZA. Probably you're wondering, why did I pursue my study in law? Mostly people avoid this course because they think it was difficult and a complicated course. Well, it's not the same thing. To me, there are few reasons why did I want to study in law. First and foremost, this course provides multitudes of career options. But my true intention is I want to protect my family and everyone from any allegation or claim. I think that answers your question. Done with the introduction part, so let us proceed to the next part. Then I will give my legal opinion on how to resolve the issue given by Madam Farhanin. On 18th June 2022, Andika Bernadi offered to sell 3 albums collection of Lee Min Ho to Atika at 1,000 ringgit, 50% less than the market price. His offer was made by phone and he also asked her to inform the acceptance through WhatsApp before or on 20 June 2022. He also advertised in Shopee and Lazada to sell those collections at a higher price. After 1 hour, all the 3 albums were sold out and he even posted the albums to the buyer on the same day. He then intended to inform Atika on the non-availability of the albums, but his internet connection was not good at that particular time and he forgot to inform Atika after that. On 20th June morning, Atika called Andika to accept the offer and claimed that Andika had breached their contract when sold the album to Atika's best friend without informing her earlier. She also claimed that she only knew the non-existence of the album when her friend came to her house on 19th June to inform her. The first issue is regarding to Andika, whether the communication of revocation by Andika was valid. Under Section 4, Subsection 3 of the Contract Act 1950, it stated that the communications of a revocation is complete as against the offer when it is put into a course of transmission to the person to whom it is made, and the revocation becomes effective when it comes to person's knowledge. In addition, the communications of revocation does not to be made by the offeree personally, but it can also be made through the third party. This can be considered as indirect vocation. Referring to the case of Dickinson's against Dodds, the court held that the offer can be revoked at any time before there is acceptance from the complainant and the communication by a friend of another party of the withdrawal of the offer is still effective, since it is treated as if it came from the offer or himself. Applying to this case, Andika did try to contact Atika about the unavailability of the albums before the acceptance from Atika was made. Due to the internet connection problem, he couldn't contact Atika, and when he can, he forgot to tell Atika about it. Turns out Atika knew about the unavailability of the album from her best friend that bought the album from Andika. We can see that Andika was not bound by the promise and may sell the albums to other people because Andika's offer is just a mere offer which can be withdrawn at any time. Every buyer want to make a deal with a serious buyer. But in this case, Atika did not giving any response after the offer was made to her. To conclude this, the communications of revocation made by Andika is valid since Atika are fully aware about the album are no longer available for her. Moving on to Atika's issue is whether the acceptance by Atika is valid. Under Section 7, Subsection B of Contract Act 1950 provide that the offer or had prescribed the means of communications, the offeree must follow it. Applying to this situation, Atika failed to make the acceptance through WhatsApp, which was prescribed by Andika at the time they communicate regarding the offer. Instead, she just made a phone call to accept the offer. Here is the proof that she did not follow the exact manner prescribed by Andika before. Besides, she knew about the unavailability of the album but still insisted on accepting the offer. However, the offer between Andika and Atika was already invalid since he sold the album to Atika's best friend before Atika made her acceptance. To conclude this, the acceptance made by Atika is invalid since the offer between she and Andika are no longer exist since the album already had been sold to her best friend. In addition, Atika also in fault because she is not followed the exact manner specific by the offeror. Automatically, the acceptance become invalid. That's all from me, and I would like to say thank you for watching my presentation. See you next time.